Okay, in this presentations, we will discuss under the topic relevancy, admissibility of dying declarations provided under Section 32 of the Indian Evidence Act. Here, Section 32, it provides cases in which statements of relevant fact by persons who is dead, who cannot be found, who has become incapable of giving evidence, whose attendance cannot be procured without unreasonable delay or expenses. Here, these statements made by persons will be relevant. It may be in civil proceedings or it may be in criminal proceedings. When there is questions arises in relation to the statement of these persons under the dispute, which are in trial or which are in prosecution of the court, that is at the moment of the prosecutions, at the moment of the proceedings, that is here statement made by persons who is dead, that means who has already expired, that is who has already expired from this world, who have no afference now, that is who has no existence in this world now physically, that is and who cannot be found. It means in spite of reasonable search, he could not be found. In spite of reasonable search, these persons could not be found. If his identity cannot be traced out by the authority, that is, or maybe presumed died, that is, this is the who cannot be found, that is, it comes under the concept of who cannot be found, that is, and who has become incapable of giving evidence. It may be due to physically unfit, it may be due to blind, or due to old age, or due to insanity. That is here, and the persons whose attendance cannot be procured without unreasonable delay or expenses. That means, suppose a person now which the court requires in the proceedings or trial, suppose these persons are outside the jurisdiction of India, suppose it is far from India, the production of these witnesses may be late, may be delayed for the dispensation of justice. That is, in these cases, this kind of false statements made by persons will be relevant under Section 32. It is Section 32 provides about this. Now, what are the statements given under Section 32 that such person's statement will be relevant, will be admissible either in civil proceedings or criminal proceedings? Now, these statements you see, there are total 8 statements is given under this Section 32. Here, at first given number 1, when it relates to cause of death. That is, uh, when the statement made by persons as to the cause of state or as to the transactions by which cause of state, that is, regarding the transactions under which occurrence this person is dead, that is, regarding these relevant statements of the deceased persons will be relevant, will be admissible in the criminal prosecutions, that is, and second statements here given is made in course of business. Here, here, suppose in the ordinary course of business, discharge of professional duty here, or of an acknowledgement written or signed by him of the receipt of money, goods, securities, or property of any kind. Here, such persons, such statements, when such persons, whoever made the such statements, if it is not possible to produce as a witness in the court, then these statements of these persons will be relevant, whatever they have made in the ordinary course of business. It is admissible in civil proceedings or it may be in criminal proceedings. And number three, these statements against interest of the maker, that is, it says that if this statement is against the pecuniary or proprietary interest of the person making it, it would expose him to a criminal prosecutions or to a suit for damages, that is the civil prosecutions. Whatever he made statements against his interests, if these persons cannot be produced as witnesses in the proceedings of the court, then his statements will be admissible as an evidence in the court, that is. And the number four statements, it provides about the opinions, whoever giving opinions as to the public right, custom, or matters of general interest, that is. Here, a question is regarding the particular public rights here. Regarding the particular public rights, which may be based on the custom also. If some person they have made statement regarding this particular public rights, whether they can enjoy this rights or not in a particular moment. If the maker of such statements they cannot be produced as an evidence in the court, then such statements of this person will be relevant, will be admissible in the proceedings of the court. That is, and number five statements, it relates to relationship, existence of relationship, that is by blood, marriage, or adoption. That is, here the person making the statements had a special means of knowledge regarding this such relationship. It may be by blood, or it may be by adoptions, or it may be by the marriage. That is, in these cases, and it must be met before the dispute, before the question in dispute arises. That is, regarding a particular child is not the son and daughter of these persons. Here, regarding this relationship, with the question arises, it may be in the legal here, in the moment of the transaction of the property, under the will, or under the some circumstances. Here, these statements whatever we made about the existence of this relationship, if the maker of these statements is not in existence in this world now and cannot be produced as witness at the court, then these statements of such persons will be relevant to this. And number 6, it says statement made in will or deed relating to family affairs. Relating to family affairs, it may be property or it may be some intangible property. Whatever the pedigree, that is, whatever the ancestors of this family, they have made statements. If they cannot be produced as an evidence, their statements will be relevant in proceedings. That is, and number 7, statements in document relating to transactions mentioned in section 13, here clause A. That is, here section 13 clause A, it provides about any transactions by which the right or custom in question was created, claimed, modified, recognized, ascertained, or denied, or which was inconsistent with its existence. Here, this statement is contained in any deed, will, or other document which relates to any such transactions, as is mentioned in section 13 clause C. Here, regarding any transactions, that is, it provides about it. Here, with these statements, there may be rights created, there may be recognition of these certain rights, that is, by the very statement of these persons. Then these statements regarding these transactions, it will be admissible as an evidence. And number 8, here number 8 provides the statements here made by several persons and expresses feelings relevant to matter in questions. That is, here it provides about the refers to the single statement jointly made by a number of persons to matter in question. That is, for example, the exclamations of a crowd, that is, regarding the some particular incidents, regarding the some particular kind of disputed matter, whatever the persons, they have made jointly statements at the same time. That is, whatever they have seen, whatever they have perceived with their 5 senses, that is, of human being. That is, and if the maker of these statements cannot be produced as a witness in the court, then the statements of these persons will be relevant, will be admissible as an evidence. That is the clear provisions given in section 32. Here, now the conditions of admissibility, under which conditions it is admissible as an evidence. Here, in order that a statement may be admissible under section 32 clause 1, some conditions must be complied with. That is, under the clause 1 it says that the person making the statement must have died. That is, and the statement must have been made as to cause of his death or as to the circumstances of the transaction resulting in his death. That is, and the cause of his death must be in question. That is, and the person making the statement must be in a fit condition to make these statements, and this statement must be complete and the declarant must be competent, must be mentally sound, that is, and it must be statements, it may be written or verbal. Whatever these statements we have already discussed, it may be by written representations or it may be by verbal. It may be in some written form or it may be some verbal form. That is here. Now the as a general rule, we got it. Hearsay evidence. Whoever heard from other person, this person's statements will be not admissible in criminal prosecutions. That is here. Now these exceptions is given under section 32 and 33 of the Indian Evidence Act. Hearsay evidence is not admissible because it is not made on oath, and its veracity, its truthfulness cannot be tested by cross-examinations in the court. That's why hearsay evidence, it is not admissible. But in section 32 and 33, it is the exception of this general rule. These declarations, whatever we got under section 32, it comes under the concept of the hearsay evidence. These persons cannot be produced as an evidence in the court as a witness, although these statements of these persons will be relevant, will be admissible in the judicial proceedings. It may be criminal prosecutions or it may be in civil prosecutions. That is here. Now the reasons of admissibility, we have to find out the some reasons why it is admissible. Here we got that the main principle on which dying declarations is admitted is expressed in the common maxim. That is here the common maxim is that nemo moriturus presumitur mentere. That means no one at the point of death is presumed to lie. That is here a man will not meet meet his maker with a lie in his mouth. That is this common maxim means that at the moment of the expectation of death, no persons will tell a lie. That is the reasons based on the conscience. It is dying declaration is relevant and admissible. And you have to give attention in clause second paragraph of clause 1 of section 32. Here second paragraph of clause 1 of section 32, it makes two important differences from the English law. Our Indian Evidence Act, second paragraph of clause 1 of section 32, it makes differences, two important differences from the English common law. Here, under the English common law, it is provided that these dying declarations must be made under the expectation of death. But in our Indian law, the dying declaration may be made. It may be under the expectation of death, or it may not be under the expectation of death. But this statement of persons who has already expired, his statement must be related in dispute under the proceeding in our Indian criminal prosecutions. That is in under judicial proceedings. That is the number one departure from the English law, and second departure from the English common law. That is here under the English law, dying declarations is admitted only in criminal proceedings. In cases of homicide, that is the murder or manslaughter. But in our Indian law, the dying declarations, it is admissible both in the criminal prosecutions and civil prosecutions. This is the two concepts we got, departure from the English common law. You have to remember, so much important that is. And now the evidentiary value of dying declarations. Why it is admissible, why it is reliable, that is. Here, uh, if the court is convinced, if the court can establish based on the statement of the dying declarations, here, if the court believes that it is true, then it can base convictions on it. It can the court can convict the accused persons based on the statements of these deceased persons. Here, there is no rule which requires that a dying declaration should not be acted upon unless corroborated. Uh, Here, in our Indian Evidence Act, there is no express provisions that by the statement of the dying declarations, the accused persons cannot be convicted. It is not expressly given. But it is expressly given that based on the statements of based on the declarations of the deceased persons, convictions can be given to the accused person. It is expressly given. We have to remember about this. It is admissible based on the statement of deceased persons. Accused person can be convicted. That is. Now, now the merits of dying declarations. We have to draw some. We have to draw out some merits of the dying declarations. Here, number one merits. There is a heavy conscience, and second one is there is no reason to implicate wrong person. There is no reason to indicate the wrong person, and there is no reasons why he will avoid the name of the accused persons. Under the expectation of that, there is no reason to avoid the name of the accused persons, the name of the perpetrators, the name of the offender. That is, there is no reason to avoid the name of the perpetrator or name of the offender by the persons who are under the expectation of that. And these are the reasons. That's why it is admissible in our judicial proceedings. That is. Now, defects of the dying declarations. What are the main defects? Demerits. We have to draw the demerits also. In every law there is demerits also. We have to draw. That's why. Here, there is no oath administered of the such persons because these persons cannot be produced as an witness before the court proceedings because they have no existence in this world. That's why they cannot be administered by oath taking before the court, before the magistrate, before the judiciary. That is. And second, demerits, that is, there is no cross-examinations, that is, of such persons making dying declarations. This person cannot be produced as a witness, that's why it is not possible to cross-examine such persons, that is. And witnesses is not present in the court due to death, due to cannot found, due to incapable of giving evidence, or due to cannot be procured without unreasonable delay or expenses. And there may be the result of tutoring, that is, by the interested parties. There may be a result of tutoring, that is the suggesting, that is the monitoring by the persons who are interested. That is, these are the demerits of why the dying declarations in some extent it may not be it may not be admissible. Here, the court, magistrate, judiciary, they must have to give attention to this also. That's why they have to proceed very cautiously. Here after this we have discussed this section 32. It is. Now the section 33, this also covers under the concept of the provisions of the dying declarations. Section 32, section 33 also comes under the dying declarations. You have to remember, don't confuse regarding this. Section 32 and section 33, they come under the concept of the dying declarations of the witnesses. Dying declarations of the persons who is dead, who cannot be found, who is incapable of giving evidence, who cannot be procured without unreasonable delay or expenses. Here section 33 it provides that. Relevancy of certain evidence for proving in subsequent proceeding, that is, the truth of facts, whatever they have stated. It is expressly given in section 33. Here, section 33 makes depositions in a formal trial or proceeding relevant as substantive evidence in subsequent proceedings. That is, whatever the persons who cannot be found, who is dead, who cannot be, who is incapable of giving evidence, and who cannot be procured without unreasonable delay or expenses. Here, whatever they have made depositions in the previous trial or proceedings. Now, if these witnesses are not, if these witnesses cannot be produced due to reasons whatever we mentioned under four circumstances, physically at the court, then whatever they have made deposition statements at the formal trial or proceeding, their statements can be produced in the subsequent proceedings. That is, here, that's why section 33 also come under the concept of the dying declarations. That is, here, after this, we discuss the details concept of the section 32 and 33. I think we have got a clear concept. Okay, that's all today. Bye. Have a nice day.